Greetings. You received a call from the pharmacy tech at 7:47 p.m. directing you to Walgreens on Ashford the next morning upon opening. Mr. Monroe, he didn't disclose specific details over the phone. He requested you come alone. Perplexed in your studio apartment, which has been your residence for 6 weeks since Amber changed the house locks, you pondered how Holly from the pharmacy obtained your number. Suddenly, it struck you emergency contact on Macy's ADHD medication. It was over 5 weeks since you last saw your daughter due to Lorraine, your mother-in-law, calling the police, claiming you were unstable and dangerous. During that traffic stop, they discovered pills in your car's center console, which weren't yours. You had never seen them before the deputy opened the armrest and retrieved an amber prescription bottle with a peeling label. The content was hydrocodone, 60 count, without any visible name. They didn't arrest you that night. Instead, they took the bottle as evidence and submitted a report. 72 hours after Lorraine presented a report to family court, she attached it to an emergency custody petition depicting me as a drug addict hiding pills in my vehicle used for our daughter's transportation. Amber remained silent at the hearing, sitting beside her mother while I attempted to clarify to Judge Kellerman that I had never consumed opioids. Temporary custody was granted to Amber with supervised visitations only, and I was given 2 hours per week in a state facility under surveillance by a social worker, which occurred on October 9th. Holly's call came on November 20th. I arrived at Walgreens at 8:03 a.m. Waiting near the pharmacy counter was Holly, a slim woman in her 50s with reading glasses hanging from a chain. Upon spotting me approaching the consultation room, a small space with a desk and chairs where pharmacists discuss medications with patients, she closed the door. She said she needed to show me something, but first, I needed to know why she was showing it to me. She extracted her phone, displaying the prescription bottle taken by the police from your vehicle, the one with the partially obscured label, a detail I'd never noticed before its discovery. True, I understand. On her screen appeared an image of a pristine prescription bottle, complete label included. This was from our records, hydrocodone, 60 count fill on October 4th, prescribed to Lorraine Vance. Your mother-in-law picked it up on the 7th. I recall this distinctly due to her grumbling about the cost, even with insurance coverage. My heart constricted. Why are you informing me of this? Because exactly 3 days later, she requested a replacement label for the bottle, claiming hers was damaged in her purse. Holly scrolled to another image, a printed request form. Normally, we don't accommodate such requests, as labels don't typically detach easily. However, given her status as a long-term customer, my manager granted her a duplicate label. I found it peculiar. Did you issue the duplicate label yourself? No, but I saw her conversing with your spouse in the parking lot on that day. I identified Amber due to her visits dropping off your daughter. Holly presented another image, captured by our exterior security camera on October 10th at 9:40 a.m. This photograph shows Lorraine, your wife, getting into the passenger side of her car. The timestamp was 2 hours prior to my traffic stop. Holly enlarged the image. Lorraine's hand appeared to be passing something small to Amber. Although the angle wasn't ideal, the shape was distinct, a prescription bottle. Holly stated, I can't confirm what she held, but I can prove she requested a duplicate label 3 days prior, and I can prove she handed over something to your wife 2 hours before the police found pills in your vehicle. She added, I can also show those pills matched a prescription filled here for Lorraine Vance. I fixed my gaze on the phone screen. Why are you assisting me? Because I witnessed my sister lose custody of her children to a man who deceived judges for 2 years. She lacked evidence. You possess it. Holly retrieved a thumb drive from her pocket. All relevant documents are available. Prescription records, form for label requests, surveillance videos, timestamp information is incorporated within the files. Your legal representative will determine the best course of action with this data. I took the drive, my hands were unsteady, and there was one more thing Holly mentioned. Lorraine filled another Ambien prescription yesterday, a 30-count bottle which she shared with our tech, stating she's been struggling to sleep. She stared directly at me, a look typical of guilty individuals. My attorney, Bryce Whitfield, scrutinized the security footage multiple times without uttering a word. Afterward, he examined the prescription records, matched the pill bottle serial number from the police report with that in the records, and finally relaxed in his chair. This evidence is prosecutable, he asserted. Potential offenses include tampering with evidence, falsifying reports, and depending on our investigation's depth, your mother-in-law could face criminal charges for conspiracy to interfere with custody. As for Amber, She appears in the footage, but proving she knew what she was given will be necessary. The defense asserts Lorraine claimed it was aspirin or vitamins unless she admits knowledge. Otherwise, it's circumstantial. Bryce tapped his pen on the table. However, here's what we can establish. Lorraine had a prescription, requested an unusual label change, met with your spouse 2 hours prior to your appointment, and subsequently filed a custody petition using potentially planted evidence. This is enough to undermine her credibility and reinstate your custody. When can we present our case before Judge Kellerman? I'll submit an emergency motion tomorrow. With this evidence, we should secure a hearing within 2 weeks. He paused. But Garrett, I must inquire, do you wish to press criminal charges against Lorraine or simply regain your daughter? I pondered Macy. Her tears during our last supervised visit as she questioned why she couldn't come to my apartment, and Amber's lie that made me seem like someone in rehab. I replied, both. I desire everything, the hearing. 7th of December. Judge Kellerman privately scrutinized the pharmacy evidence for half a quarter hour before summoning us into the courtroom. Lorraine sat alongside Amber, maintaining a calm demeanor until Bryce displayed the surveillance footage from Walgreens on the courtroom screen. For integrity's sake, this exterior recording is dated October 10th at 9:04 am. Bryce utilized a laser pointer to highlight key moments. Here's Lorraine Vance exiting the pharmacy. Here's her vehicle. And here's Amber Monroe entering the passenger side. The footage was played, capturing Lorraine extending her hand and Amber accepting something within 4 seconds. The timestamp indicates this transaction happened 2 hours before the police stopped Mr. Monroe's vehicle and found prescription pills. Bryce presented a document, revealing pharmacy records stating that Lorraine Vance requested a duplicate prescription label 3 days prior, claiming damage. The prescription was for hydrocodone, with 60 tablets listed in total. The bottle serial number matched the one seized from Mr. Monroe. The serial number on Monroe's vehicle corresponds with Mrs. Vance's prescription. Judge Kellerman's expression was indecipherable as he looked at Lorraine. Mrs. Vance, he asked, do you have a reply to this evidence? The young lawyer representing her, who had been fidgeting with papers since the footage began, stood up. Your Honor, my client maintains innocence. The video shows a conversation rather than a crime, and we lack proof of the contents of their exchange. Without being prompted, Bryce spoke. We also have a sworn affidavit from the pharmacy technician who handled the duplicate label request. She found it peculiar and recorded it internally. Alongside the meeting 2 hours prior to the traffic stop, the pattern is evident. Judge Kellerman addressed Amber next. Mrs. Monroe, what did your mother hand you in that parking lot? Amber looked at Lorraine and her lawyer, then back at the judge. Amber doesn't recall specific details about a meeting that took place 8 weeks ago, possibly concerning vitamins since her mom often provides her with supplements. In a pharmacy parking lot, 2 hours before your husband was apprehended with prescription pills similar to her mother's medication, Amber seemed flustered. She's unsure about what exactly she received from her mother. Judge Kellerman paused his questioning. Mrs. Monroe, I'd like you to understand that your response could influence the court's perception of your credibility. He inquired, did you know your mother intended to file a custody petition against your husband? Amber remained silent for a while before responding. Yes, she mentioned it. Kellerman then questioned further about the timing. When did this occur? In October, either the 8th or 9th. And was this before or after the traffic stop? Amber responded, before. The judge then closed the file in front of him and declared, I'm instructing an immediate investigation by the county prosecutor's office into potential evidence tampering and false reporting. Vance, avoid any interaction with the minor child until this investigation concludes. Mrs. Monroe, your custodial rights remain unchanged, but Mr. Monroe's visitation resumes to regular parenting time without supervision, starting now. Lorraine stood up. Your Honor, what's this about? Please, Mrs. Vance, have a seat, he replied. You will be given a chance to defend yourself if criminal charges are brought against you. He looked directly at me. Mr. Monroe, I offer my sincere apologies for the ordeal you've endured. The court regards baseless allegations with gravity, Bryce whispered beside me. You're regaining custody of your daughter, but I noticed Lorraine's expression when she saw her case crumble. It wasn't surprise, it was strategizing. She's already devising her next steps if criminal charges are filed, which takes around 6 weeks to process. The prosecutor's office spoke with Holly, scrutinized the surveillance footage, and summoned Lorraine's phone records. The initial tip in the investigation, submitted anonymously via CPS, originated from a prepaid mobile phone bought at a gas station 3 blocks away from Lorraine's residence. The credit card for the purchase bore her name. In mid-January, Lorraine was indicted on charges of tampering with evidence, filing a false report, and conspiring to interfere with custody. Her attorney negotiated a plea deal, resulting in 2 years of probation, community service, and a permanent restraining order that prohibits her from approaching Macy and me. In February, Amber filed for divorce, citing irreconcilable differences and seeking primary custody. She overlooked her mother's plot and her silence during my loss of access to our daughter. Her lawyer attempted to argue that Amber was influenced by Lorraine and should not be penalized. However, my attorney countered this point. We submitted a counterappeal with a chronology of Amber's actions, the parking lot encounter, her concealment of truth at the emergency custody hearing, and her denial of my visits with Macy, even informal ones. The documents also contained financial records, which led to an intriguing turn of events. Bryce discovered something during discovery that I was previously unaware of. A life insurance policy on me, obtained by Amber 2 weeks before the accident in September. Its value, $500,000. Beneficiary, Amber with Lorraine as a secondary. According to Bryce, when he presented the policy documents, she wasn't just trying to keep your daughter from you. She was strategically securing her finances. If my reputation were ruined, earning potential significantly decreased or worse. If I had been convicted and lost permanent access to Macy, she would have primary custody while still requiring child support payments, effectively cutting me off from my daughter's life. During this tumultuous phase marked by addiction, he left his sentence in suspense. I felt a chill run down my spine. You suspect she wished for my demise. I believe she craved alternatives, and your mother-in-law offered a guide. He produced another paperwork. Lorraine revised her will in October. A new clause was added. Should anything befall Amber, Lorraine would acquire guardianship of Macy and authority over a trust financed by your insurance settlement payout. This wasn't merely about child custody. It concerned money, power, and erasing me completely from their schemes. The divorce trial was scheduled for April, but an event in March altered everything. Lorraine was deeply involved with Covenant Hill Community Church, a position she held dearly, serving on 3 committees, organizing the annual fundraiser, and even deciding to proceed with their spring gala despite her legal entanglements. The theme was Pillars of Faith, celebrating members who had shown dedication to the congregation. Lorraine was to be one of those honored. I learned from Macy in our visitation session that Grandma will be honored at church. She's receiving an award for allegedly framing her son-in-law with planted drugs to take custody of her daughter. I contacted Bryce about this matter, questioning if it's permissible to present evidence in a public setting when the evidence isn't sealed by a court order. What are your thoughts? Lorraine is being recognized at a church fundraiser in 2 weeks for actions that were exposed during a criminal case. The security footage, prescription records, and timeline, none of which have any gag orders, are now public due to the case. Bryce hesitated for a moment before responding. Are you considering revealing her actions during a church event, potentially causing a scene? You wish for people who view her as a pillar of faith to know her true character. This is courageous and possibly beneficial for healing. He then added that such an action could lead to lawsuits if defamation occurs. However, if you focus on documented facts and evidence from the public court records, it would be difficult for her to claim damages. You should be cautious with your approach. I won't rant. Instead, I'll present the footage and documents, letting the evidence guide us. Technically, it isn't illegal or morally questionable to disrupt a church event. However, it might appear that way. He seemed almost amused. Are you asking me to accompany you as your lawyer if things escalate? No, I replied. I want to handle this on my own. The Covenant Hill Spring Gala was held in the Fellowship Hall, a spacious area with round tables, a stage, and a silent auction along the back wall. I arrived at 7 p.m. wearing a suit, carrying a laptop and a small projector borrowed from a friend. No one challenged me at the door. I blended in as any other attendee. I took a seat near the back and waited. Dinner was served: chicken, roasted vegetables, typical banquet fare. Speeches started around 8. The pastor spoke about unity and service. Then the committee chair took the microphone to introduce the honorees. Lorraine was third. A woman in a navy dress strolled onto the stage, beaming, as she received an award while the audience clapped. The man at the podium read aloud from a card, "For 2 decades of selfless service, organizing our youth outreach programs, for your generosity and unwavering faith." I got up and walked towards the stage, attracting the chair's attention first. Lorraine's smile faded when she spotted me. "Excuse me." I declared loud enough for all to hear. "I'm Garrett Monroe, Lorraine's son-in-law. I have something that needs to be seen by everyone here before we honor this woman." The pastor moved forward. "Sir, this is a private event," he stated. "This won't take long," Lorraine said hastily. "Garrett and I have had family disputes, but this isn't the time or place." I opened my laptop on the nearest table, connected the projector, and illuminated the screen behind the stage. "I'll be done in 3 minutes, then I'll leave," I added. The room fell silent as 200 pairs of eyes fixed upon me. I reviewed the pharmacy surveillance footage, dated October 10th from a Walgreens parking lot exterior view. Pressing play revealed Lorraine Vance handing something to my spouse, captured over 4 critical seconds. The scene showed Lorraine Vance passing an unidentified item to my wife 2 hours before I was apprehended with prescription pills that were unfamiliar to me. I proceeded to scrutinize the following document, pharmacy records, which indicated that Lorraine had filled a hydrocodone prescription 3 days earlier and fraudulently requested a duplicate label citing damage. Switching to the prescription serial number comparison, the bottle discovered in my vehicle matched Lorraine's prescription, bearing identical serial numbers. A gasp echoed from someone in the audience. I refrained from looking at who it was. Lorraine exploited these falsified pills to instigate an emergency custody petition, alleging I was an addict jeopardizing my 5-year-old daughter. This false accusation led to a 6-week loss of custody. I visited my daughter twice a week under supervision while Lorraine spread rumors about my instability. I examined Lorraine Vance's court records. On January 18th, she was indicted for tampering with evidence and filing a false report. She confessed her guilt. 2 years of probation were imposed, along with a permanent restraining order from my child. The pastor confronted Lorraine. "Is this accurate?" Lorraine failed to respond. I closed the laptop. "That concludes our meeting. Thank you for your time." I disconnected the projector, gathered my equipment, and departed. The room remained quiet until I reached the door. Then murmurs began, followed by louder voices, and eventually someone demanded an explanation from Lorraine. I left without watching further. I'd expressed what was necessary. The following day, Lorraine resigned from all her church committees. The pastor phoned me personally to express his apologies, stating the board had no knowledge of the legal situation. 3 individuals from the congregation contacted me through Facebook, expressing their suspicion of manipulative behavior by Lorraine for numerous years, but lacking concrete evidence. The church board covertly refunded her donations from the previous year and eliminated her name from the memorial plaque list of contributors. A week later, Amber's lawyer spoke to Bryce about a revised settlement offer. She proposed an equal custody arrangement, no child support demands, and the withdrawal of her request for spousal support. In return, she asked for my agreement not to pursue any financial claims linked to the life insurance policy or her role in Lorraine's scheme. Bryce stated that she is in a tight spot. If this case goes to trial, the life insurance policy alone will make her seem implicated in a conspiracy. The judge will damage her credibility. What should I do? Take the deal. You get shared custody, no financial responsibilities towards her, and you can move on. Proceeding with further claims would cost another year of legal expenses and emotional effort. Stability matters more to Macy than revenge against Amber, as acknowledged. In May, I endorsed the divorce settlement, and it was finalized in June. Currently, Macy spends alternate weeks with me and Amber. She's progressing well through therapy, according to her counselor. Sometimes she queries about Lorraine, to which I reply that Grandma made some regrettable decisions and needs time to reflect on them. Amber and I only communicate about logistics. She has moved to an apartment elsewhere in the city. Rumors suggest she's working as a receptionist now, with their joint funds depleting due to Lorraine's legal fees. I'm uncertain about these reports and uninterested. What concerns me is ensuring Macy feels secure with me during my weeks, that she sleeps peacefully in her room at my apartment, and that she isn't being raised by individuals who consider framing someone for a crime acceptable if it aligns with their objectives. Holly from Walgreens sent a card to me in July, containing a brief message. "Delighted you retrieved your daughter. You were entitled to the truth." She is correct. The truth was all the vindication I needed, especially when I presented it to the appropriate audience at the optimal time with compelling proof. Lorraine aspired to be respected as a pillar of faith. Instead, she was unmasked as a charlatan in front of everyone who trusted her. I didn't ruin her reputation. I merely exposed her true nature, and it seems that was more than sufficient.